Good day everyone, this is Marinela L. Aldovino. Today, I am going to discuss the prosecution, the second pillar of the criminal justice system. So when we say prosecution, it is the process or method whereby accusations are brought before a court of justice to determine the innocence of guilty of the accused. The prosecution will be the one to gather necessary evidence with the help of the law enforcement pillar, and they will be the one to determine the existence of prima facie case and file the prosecute the case in court. So after the police or the law enforcement pillar, sa prosecution na po tatakbo ang criminal justice system. Prosecution will be the one to determine the existence of prima facie case, or yung ating basihan that there is really a crime committed, and also for the prosecution. This pillar will be the one to prosecute and file the case in the court. So let's proceed the role of the prosecutor. This is serving as the lawyer of the state or government in criminal cases. The prosecutor is automatically considered as officer of the court. At the same time, the prosecutor is formally a member of the DOJ under the executive branch of the government and is thus independent for the judiciary. So when we say serving as the lawyer of the state government, the prosecution ay ang kinatawan or ang representative ng ating government sa mga criminal cases. The prosecutor ay ang abogado na ang people of the Philippines na every time na may hearing, sinasabi ng judge ang appearance. So when the judge say appearance, the prosecutor po is magpapakilala at sasabihin niya na I'm public prosecutor, then her or his name, and respectfully appearing for the government, Your Honor. The prosecutor ay abogado na kinatawanan ng ating government. So next is the differences of prosecutorial discretion and selective prosecution. So prosecutorial discretion, the prosecutor screens and evaluates the document in order to decide whether to accept or reject the case for prosecution. So dito po sa prosecutorial discretion, ini-evaluate ng ating mga public prosecutor yung mga documents whether that is sufficient na mag-file ng case. While the selective prosecution, this is the responsibility of the prosecutor to evaluate the evidence that the police have gathered and decide whether it is sufficient to warrant the filing of charge against the violator. So, ibig sabihin po is selected prosecution po is ang responsibilidad ng prosecution ay i-evaluate ang evidences na nag-gathered or na-accumulate ng ating mga kapulisan, whether yun ba ay sapat na makapag-file ng charge laban sa suspect. So, let's proceed what is the legal factors considered by a prosecutor under selective prosecution. First is the legal strength of the case. Ito ay kung malakas ba ang kaso or kung meron bang pag-asa or kung meron bang laban ang kaso. Second is the suspect is in fact guilty. Third is the willingness of the witnesses to testify. Fourth is the likelihood that the prosecutor can legally prove the defendant guilt. And for the controversial expression of prosecutorial discretion, the decision to mitigate the defendants through reducing the charge. So dito po is the prosecutor uses discretion to reduce the charge. Like imbis na murder po is nagiging homicide na lang po siya. So next is number 2, dropping multiple counts. To leave a single charge, the prosecutor can drop several charges and come up with only one single charge. Number 3, recommending leniency to the court at sentencing parallel prison sentences. So making sentence is recommendation. It means that is the accused pleaded guilty and he is the first time offenders or minor. The prosecutor can recommend for lighter sentence. This is the only stage that the prosecutor can make recommendation. That's why plea bargaining is very important, so that the prosecutor can recommend whether to lessen the sentence. So, who composed the prosecution? So, we have prosecutor or the so-called fiscal. First is state prosecutor, second provincial prosecutors, city prosecutor, and last is special prosecutor. The attorney is private practice. They represent the parties, complainants, or respondent in proceeding before the public prosecutor. And next is public defenders such as PAW, other legal aid lawyers. So, what is the duties of prosecutor? So, the duties of prosecutor is to evaluate the police findings referred to them or the other complaints filed directly with them by individual persons. Next is file corresponding information is proper court on the basis of their evaluation of the proof at hand. And number 3 is prosecute the offenders in court in the name of the people of the Philippines. So next is the definition of preliminary investigation. So when we say preliminary investigation, an inquiry or proceeding for the purpose of determining whether there is sufficient ground to endanger a well-founded belief that a crime cognizable by the RTC has been committed and that the respondent is probably guilty and should be held for trial. The officer authorized to conduct preliminary investigation. First is the provincial or city fiscal and their assistants. Second is national and regional state prosecutors. And lastly is such others officers as may be authorized by law. So let's proceed the arraignment. So when we say arraignment, the legal mechanism whereby an accusation is brought before the court wherein the complaint or charge against him is ready by the clerk of court in the presence of a lawyer, presence of the lawyer and the prosecutor, in which the accused is to announce his plea. The arraignment po is ang pagbasa ng sakdal sa ating mga akusado. So, next is, let's focus the plea bargaining. So, when we say plea bargaining, the process of discussing or negotiation between the defense counsel and the prosecutor aim at reaching an agreement whereby the prosecutor uses discretion to obtain from the judge a lighter sentence in exchange for the defendant entering a guilty plea. So, we have prima facie evidence. So, when we say prima facie evidence, it is such establish a fact or explained by evidence became conclusive, and it is considered as a fully proved. Denotes evidence which, if unexplained or uncontradicted, is sufficient to sustain the proposition it supports, or establish the fact as to counterbalance to presumption of innocence to warrant conviction. So we have compliance. A sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or the public charged with the enforcement of the law violated. And information. When we say information, is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. And next is subscribed by the prosecutor and filed with the court. And this is the information. And investigation of a case performed by the fiscal assigned, and it is still part of preliminary investigation. So other officers authorized by law, which is COMELEC. So COMELEC is the conduct preliminary investigation on all election cases under the Omnibus Election Code 1987 Constitution mandates the COMELEC not only to investigate but also to prosecute cases of violation of election law. Next is PCGG. So when we say PCGG, prosecution for violation of RA 3019, unexplained wealth. The office of the solicitor, the office of the Solicitor General can legally represent respondent government officials in preliminary investigation in the prosecutor's office on charge of violation of anti-graft law. And lastly is the military tribunal. It is governed by the articles of war rather. So that's all. Thank you.